LIEnette has now dodged yet another deposition. If LIEnette is as innocent as she continues to post online, as she wants her truth to be known, as she keeps telling everybody, dig for the truth, then why doesn't she show up for her depositions? The one opportunity to tell the truth. I bet you I know why. Deuce. There's no way in Hale's Deuce wants her in front of a camera with another lawyer, with the opposing counsel, telling the actual truth. Deuce already knows that LIEnette has literally handed over the smoking gun to the Levy County Sheriff Department on her own husband, as we're going to see soon here in her filing. Now, if she's willing to toss John CROOK under the bus, or RV, what's she willing to do to save her own skin to Deuce? I have no doubt whatsoever that Deuce continues to give LIEnette and CROOK horrible, absolutely horrible legal advice. Like, don't show up for your depositions. No, there won't be any consequences. Oh my, but there are. And there are a lot. You see, the dupe, the game, Deuce's dupe, started yet again last night. Last night, CROOK was in another individual's chat, a live stream. We're going to call them the anti-what the Hales ecosystem. Another one of these individuals, the bootlicker. Sick. And CROOK says in that live stream, and I'm quoting, "I just finished fencing in 3 sides of my property." Hold a second, I thought it was LIEnette's property. And let's face it, it ain't going to be theirs for long anyway. They're already going to have judgments against them for the Trespass 5 case. They're going to have judgments against them for the thumbnail case. And that's not even getting into the Ohio case, which there is another hearing next week. Now, they will not be a part of this hearing. This is an emergency ex parte hearing that does not involve them based on what Vomit did with them. But we'll get to that next week. And, well, yes, that's right. We have also, the federal cases. Oh, boy, so many cases. And CROOK has this to say in a live stream. "I just finished fencing in 3 sides of my property. I'm so ready for my shoulder injections tomorrow. And right at the end, I stepped in a hole and I twisted my knee good." I've never heard of anybody twisting their knee good, nor do I ever hear of individuals who live on a piece of property illegally in a shed with no bathroom needing shoulder injections. Nor have I ever understood how any type of shoulder injection could get somebody out of a legal deposition. Because LIEnette then, at the last minute before the deposition, literally late afternoon before the deposition, filed this little piece of motion here, which is absolutely fraudulent. You know, one of the words she likes to say. So she files last night, and it says this: plaintiff's motion for protective order. Now, many people have already seen this and stated, oh my goodness, is she going for a civil protection order again? That's not what this protection order is. This protection order is she's filing saying, I don't want my deposition to anybody in the public. Although this is a case of public interest, it's obviously going to be in the public, right? So that's what the protective order is. She's trying to save it or protect it from being released to the public. It's going to be in the public. The judge is never, ever going to agree to this. And, well, she didn't show up anyway. So let's see why she didn't show up. She clearly states it here. Plaintiff's motion for protective orders. Comes now the plaintiff. Isn't this interesting? Who's Michelle Preston? Who is that? Hold a second. Yeah, that's right. That's her daughter. Okay. This is LIEnette Preston. You know, Ruby, who we have screenshots of her stating her name is Ruby, along with all the other insane names. So comes now the plaintiff, Michelle Preston. No, it's not. Pursuant to FRCP Rule 1.280C, file this motion for protective order pertaining to defendant's deposition set for October 1st, 2025, and would show this court the following. Number 1, As per FRCP Rule 3.220H1, counsels are to confer and agree as to a date and a time. Defendant's counsel failed to properly confer with the plaintiff and has unilaterally filed its notice of taking audio-video deposition set for October 1st, 2025. Now, let's be very clear. Number one, seems to me the last hearing, LIEnette fled the courthouse. She was ordered to go back into the judge's chambers and to work with Randy to come up with dates for the next hearing. Nobody could find her. They went ahead and set the hearing anyway. Not only to mention that, but they don't even, and when I say they, I mean LIEnette and Deuce. I truly believe that Deuce is ghostwriting this for her, and I'll get to that in just a second. But Deuce and LIEnette are misquoting or trying to use criminal statutes that do not pertain in this civil case. How stupid can you be? Seriously, how stupid can you seriously be? I mean, Deuce has proved over and over again, he is one of the worst lawyers in the history of lawyering. And yet, with all these delay tactics, he's not only proving it, he's creating a track record like nobody's ever seen before. So she's saying, hey, Randy didn't confer with me. All right, number two, plaintiff's husband. Oh, yeah, you heard that right. Look at that right there. Plaintiff's husband. Now, this is going to lead us to ask the question, which husband? Would it be husband number 1, number 2, 3, 4, 5, 6, 7? CROOK would be 7. By the way, once they got a divorce, why didn't she maintain CROOK? Oh, which, by the way, he's her soulmate. And yet, she wants nothing to do with him. Can anybody understand what comes out of this woman's mouth? This vile woman's mouth. So, number 2, plaintiff's husband. She's not married. That's complete and total lie. Fraud on the court. Husband suffers from a medical condition wherein he requires time-sensitive treatment. Plaintiff's husband has had a scheduled appointment for said treatment on the date of deposition, October 1st, 2025. All right, let's get into this. Shoulder injections? Really? Shoulder injections? That's what she's going with this time to get out of her deposition? It's not, my mom died! My mom didn't die! This isn't working with this judge by any stretch of the imagination. Now it's my husband, who isn't my husband, has to get shoulder injections. You are court-ordered to be there for your deposition. And you're claiming that your shoulder has some kind of medical treatment. It's emergency shoulder injections. We literally have the screenshots. CROOK was so stupid to go the night before to set up this con and say, oh, I got to go get my shoulder injections. And I twisted my knee. Okay, great. That has to do with John CROOK. That has nothing to do with LIEnette Preston. So, John CROOK can go in for his medical treatments. LIEnette Preston was to be at the Levy County Courthouse in a deposition for 8 hours today. 8 hours! And her excuse is, my husband, she's not married, has medical treatments. Shoulder injections are an emergency and can be rescheduled. And that's his responsibility, not LIEnette Preston's. Number 3, plaintiff is involved in a bankruptcy matter, which is scheduled for a hearing on October 7th, 2025, on its motion to reinstate the case. Please see exhibit attached, A. Okay, yeah, she does have another bankruptcy case hearing on October 7th, which has nothing to do with her deposition. Literally, absolutely nothing. She is court-ordered to move forward in this thumbnail case. Now, remember, if Deuce told her, or Jerome might have even told her, her bankruptcy lawyer, oh, yeah, don't go to your deposition, no problem. Massive problems. She is court-ordered. Again, court-ordered. Court-ordered. She doesn't show up, that's contempt. Now we have sanctions. I mean, we could just get a default judgment at this point. This is insanity. This is Deuce, who told her that the thumbnail case, once they withdraw, no, there's no countersuit, there's no nothing. It's all done, except, it's still here. She's being sued. And Trespass 5 case, being sued. These people will have nothing. Do you know that she is so foolish? She literally believes what Deuce is telling her, that claiming bankruptcy, if it's even granted, is going to get her out of any judgments in these court issues. It doesn't work that way. She will be held accountable for every judgment in all of these court matters. There's no way out. They're only delaying the inevitable. And what have we seen with the delays so far? They dig deeper holes, deeper holes, deeper holes, and the whole what the Hale's ecosystem members continue to interfight on the interwebs and give us evidence and more evidence and more evidence. It's insanity what they're doing. Okay, so she thinks, well, I don't have to go anyway because of the bankruptcy. Well, there is no guarantee, number one, that the bankruptcy is even going to be allowed to be reinstated in the federal court. So that doesn't work either. In other words, she says, we didn't confer, and states a statute that has nothing to do with this civil case. My husband has a medical issue, not her husband. His responsibility, not hers. Her responsibility is to be in court. And hey, I got a bankruptcy hearing coming up, which means nothing, not even guaranteed. Which goes on to say, wherefore, for all the foregoing reasons, respectfully request that this court issue an order prohibiting the deposition scheduled for October 1st, 2025 from proceeding as scheduled. By the way, they didn't want this to happen. So you see the night before, John CROOK is literally setting up the con. Oh, I've got a medical thing. By the way, they're trying to cover up the con even later today. And awarding with such further relief as this court deems appropriate, proper, and just under the circumstances of this matter. Wait, hold a second. She mentioned point number one, she needs to confer. Does she confer with Randy over this? Oh, yeah. No, definitely didn't. Certificate of service. We hereby certify that the following, wait, who's we? We hereby certify that the following and the foregoing was filed and served via the Florida Court e-filing portal. How's she getting on the Florida e-filing portal? On the 30th day of September, 2025 to Randall Shockett at the law group in Trenton, Florida. Interesting. That's her motion. She thought she was going to get out of it. So 9 a.m., I'm ready for a deposition. Now, you may be thinking, Jeremy, were you really ready? It looks like you're at Hale's headquarters. It just so happens that I am. As a matter of fact, during her deposition, I was teaching in auctioneer school all day, which George is a student of as well. This is week 2 of our 2-week training in auctioneer school. So we already knew. You know, you can predict the future pretty well. You look at the patterns of the people and what they've done in the past. It was evident she was never going to show. So George and I did not go to Florida. We kept on with our life here in Ohio. We went to auctioneer school, had a great time, taught all day, knowing she wouldn't show. Now, that doesn't mean that I wasn't there on Zoom. I was there on Zoom, and then nothing happened. Okay, this is her attachment as well, her Exhibit 1 for the hearing, which I will be a part of on October 7th. So since she did not show illegally, and she somehow thinks that she's got no consequences for not showing, which is hilarious, and she somehow thinks that bankruptcy court's going to get her out of all of this, which is also hilarious, that is the furthest thing from the truth. There will be judgments made. She will be financially liable, both her and CROOK. Oh, and Deuce. More to come on that. So Randy then files a motion this afternoon because she did not show up for a deposition. So let's take a look at this. Remember, she files the motion for protection in regards to the deposition. She doesn't want it out there. She doesn't even want it to happen. Okay, that's what she's trying to do. She's trying to say, hey, this deposition isn't happening. So first of all, let me be very clear. She didn't even get it in the appropriate time. She didn't respond. She's known about this. And even if anybody was to go, oh yeah, that medical thing, she could have rescheduled. She doesn't need to be a part of it. So Randy responds hours later. Response in opposition to plaintiff's motion for protective order and motion for sanctions and attorney fees. So what just happened today? LIEnette is already going to be found guilty. And now we're adding more money on that and more money on that and more money on that. She cannot, even if the bank, I can't say this clearly enough, even if the bankruptcy case goes forward, and let's say that the federal court allows her to declare bankruptcy, which I seriously doubt is going to happen, she still will be held liable for all judgments in all of these cases. The bankruptcy case does not wipe any of these judgments clean. None of them. All right, so Randy sends in on my behalf while I'm teaching in auctioneer school, having the time of my life, living my best life. Says, response in opposition to plaintiff's motion for protective order and motion for sanctions and attorney fees comes now the defendant Jeremy Hales and George and Larry Foreman, DUI Guy Plus, and through their undersigned counsel, and hereby file this response in opposition to plaintiff's motion for protective order and motion for sanctions and attorney fees pursuant to Florida Rules of Civil Procedure. Do you realize what Randy put there? Florida Rules of Civil Procedure. You know what LIEnette posted? With Deuce's help, no doubt. Criminal. That doesn't make a lot of sense. Listen, you've got criminal cases and civil cases, and the two are not the same by any stretch of the imagination. And criminal doesn't work over in civil, and civil doesn't work over in criminal. Okay. Number one, on September 21st, 2025, defendants filed a notice of taking audio-visual deposition of plaintiff Michelle Preston, scheduling the deposition for October 1st at 9 a.m. at Levy County Courthouse. In other words, she must attend in person. And there's a reason for that. She gets out of control like she has on Zoom in the past. We got a judge right there. We got sheriff deputies right there. It'll be taken under control real quick by the authorities. But Deuce doesn't want that, does he? Oh my goodness. He's got to be scared to death, knowing that she could be deposed and say absolutely anything at any time. Number two, on September 26th, 2025, defendants filed an amended notice of taking audiovisual depositions of Preston, scheduling the deposition for October 1st at 9 a.m. Levy County Courthouse. By the way, how can LIEnette file a motion saying, no, we didn't confer, this doesn't work? She obviously knew about it, right? She knew about it. She filed a motion in opposition of it. Not the brightest. Number three, on September 30th, 2025, just one day before the scheduled deposition, Preston filed a motion for protective order seeking to prohibit the deposition from proceedings as scheduled. She don't want this happening. Actually, I think Deuce, Jerome, Vomit, Paint Chips, Fleesa, Lips, Chips, Bonehead. I mean, you want me to keep going on? Stupid Lame, Making Liable Simple. None of them want this to happen because she has so much information on them. And if she's alone with another lawyer being questioned, she is going to throw them all under the bus, and they know it. Number four, Preston utterly failed to appear at today's deposition. A certificate of non-attendance is forthcoming from the court reporter. She just pulled a no-show like it was nothing. Court ordered, nothing. You know what could happen? Bench arrest. This could happen from this judge. Number five, Preston's motion should be denied for the following reasons. Number one, Preston improperly cites criminal procedure rules in a civil case. How stupid can you be? How bad of a lawyer can you be? Every time I ask it, Deuce keeps showing me how utterly dumb he is. So, Preston's motion for protective order cites FRCP Rule 3.220H1 as the basis for her motion. Number seven, Rule 3220H1 is a Florida rule of criminal procedure governing discovery depositions in criminal cases, which has absolutely no application in this civil proceeding. These lawyers, LOL. Yeah, we're laughing at them. Big time. Number eight, the correct rule governing depositions in civil cases is Florida Rule of Civil Procedure 1.310. Again, here's Randy teaching them how the law works. which was properly cited in defendant's amended notice of taking audio-visual deposition. Number 2 reason why all of this should be denied and she should have sanctions. And we go into, and it's point number 9. Again, you can see the points. This is the main point, and then we'll go down through the paragraphs. In her motion for protective order, Preston claims that her husband suffers from a medical condition wherein he requires time-sensitive treatment, and that her husband has a scheduled appointment for said treatment on the date of deposition, October 1st, 2025. I'm pretty sure they would have known about this. No, you know what? As a matter of fact, John Cook, after the no-show today, John Crook literally went into another person's chat, again to complete the con, and he states this. You see that, right? Double shoulder injections right there. That was scheduled 2 months out. Double shoulder injections. By the way, she knew the entire time this was going on, and her husband could have rescheduled. And he has nothing to do with this deposition. All right. So let's keep going on. Her husband has a scheduled appointment for said treatment on the date of deposition, October 1st. Okay, if she was knowing about all of this, then she knew about the deposition. Why did this come in at the 11th hour before the said deposition? Number 10, upon information and belief, Preston is not married and has no husband. Now, she has had 7, and that's pretty sick to think about as it is. But rendering these statements in her motion completely and totally false. You know what that is? That's fraud upon the court, and that's perjury. Do you understand how insane this is? How out of control this is? Because Deuce wants delay, delay, delay. And the more they delay, the more evidence we get, and the more mistakes these creeps make. Number 11, in a related case before this court, Preston also filed a last-minute motion to avoid a deposition, falsely stating that her mother died. Oh, so this time her mom didn't die. This time CROOK needs emergency procedures. Shoulder injections aren't emergency procedures. And trying to cover up the con afterwards in another person's chat, going, oh, my double shoulder injections, I feel so much better, is going to do absolutely nothing for them in court. Number 12, like her fraudulent, I love that Randy used fraudulent, because LIEnette loves to say that about the civil protection orders. Like her fraudulent statement yesterday about having a husband made in her motion and under oath. You understand that's perjury. Preston's prior statement about her mother dying was completely false. Preston dismissed that case while a motion for sanctions regarding her actions for avoiding her deposition were heard by the court. Number 13, Preston's sworn statements regarding a non-existent husband medical appointments constitute fraud upon the court and warrant sanctions. Could you imagine LIEnette reading this right now going, but Deuce and Jerome, they told me I could bail. I didn't have to be there. Nothing would happen. October 7th, bankruptcy. Oh no, something's going to happen, and it's going to happen very, very quick with this judge. Point number 3 of why her motion should be completely denied. I should receive sanctions and all legal fees. Plaintiff's motion was untimely filed. Right there. Yeah, well, you can't sit there the last moment and go, oh, no, I can't go. I don't want to go. So point number 3 and paragraph 14. Defendant's notice of taking audio-visual deposition was filed on September 21st, 2025, providing plaintiff with reasonable notice. That was legal notice. She could have replied that day. She could have replied the day after that, the day after that. She didn't. She had more than enough legal notice. Point number 16, the Florida Rules of Civil Procedure provide that the objections to the notice of taking a deposition include objections to the time, place, manner of the deposition are waived unless a written objection is promptly served on the party giving the notice. Specifically, Florida R Civil P 1.33 D1 states that all errors and irregularities in the notice for taking a deposition are waived unless a written objection is promptly served. Preston utterly failed to do this. Point number 17, Preston's last-minute filing has caused unnecessary delay and expense to defendants, me, including potential cancellation fees for the court reporter who appeared because she was scheduled to appear. LIEnette's going to have to be responsible for paying for all of that. Plaintiff's reference to bankruptcy matter scheduled for October 7th, 2025 does not justify cancellation of a deposition scheduled for October 1st, 2025, as these two dates do not conflict at all. Point number 19, or paragraph number 19. Florida Rule Civil Procedure 1.280C provides that the provision of the Rule 1.380A4 apply to the award of expenses incurred in relation to the motion. In other words, Florida law says she has to pay me. All expenses, all legal fees, court reporter, everything. She has to pay. Now, I know what you're thinking. She's got no money. She's got land. Completely paid for. Remember, she paid for it in cash. She's got a barn shell. Completely paid for. Remember, she paid for it in cash. She's got a septic field. Completely paid for. She paid for it in cash. Do you think I want that horrific piece of property? The stench alone is enough to not want to be on it or near it. The overwhelming, man, I just them being on it, that piece of property feels like it's cursed. I can't imagine that there would ever be enough to clean that property of the stench that they have left on it. All right, let's keep going. Okay, so point number 20, or paragraph number 20. Florida Rule Civil Procedure 1.38A4B provides that if the motion is denied and after opportunity for hearing, the court must require the moving party to pay the party or deponent who is opposed to the motion and reasonable expenses incurred opposing the motion that may incur attorney's fees unless the court finds that the making of this motion was substantially justified or other circumstances made award for the expense unjust. In other words, she has to pay. She is going to pay. I have no doubt this judge is going to file a motion and make her pay. He's already told her in the cause hearing, or the status hearing is really what it was, that she's going to be writing checks. Now, you may be thinking, now hold a second, Jeremy. He said somebody's going to be writing a check. Yeah, who's he talking to? He's talking to LIEnette. He didn't say, LIEnette, you're going to be writing a check. He probably didn't even remember her name. Although she's a hard one to forget, especially around this time of year, Halloween. The image kind of sticks with you for a little bit. But there's no doubt whatsoever she will pay for this. Number 21. Here, Preston's motion is not even remotely justified. That's because her objections raised in the motion were untimely, as they were not prompt, they were made after service of the deposition notice, and her motion raised no legitimate basis for protection under Rule 1.280C. In other words, she's screwed. Who's the people giving her counsel that she is taking? Who are the people who are telling her don't do these things? Do you realize that these people, Deuce, obviously, Jerome, obviously, and others, obviously, are only trying to save themselves. They do not care one bit what happens to her. That's pathetic. I don't like her at all. Not even the slightest bit. She is a horrific, vile human being, and so is John CROOK. And yet, nobody deserves to be duped. Nobody deserves to be taken advantage like this, like they've done to her. I don't think what she's done is right, what she's done to us, nor do I believe what these others are doing to her is right. All of it is wrong. It's pathetic. It's horrific. Nobody should have to live like this. All right, let's keep going. Law number 22, or paragraph number 22. Defendants have incurred substantial attorney fees and cost in opposing the motion for the protective order. This, what I had to pay my lawyer for writing this, she's going to have to pay for. Number 23, under these circumstances, an award of sanctions, including reasonable attorney fees and costs, is appropriate and just. Wherefore, the defendants respectfully request that this honorable court, number 1, deny plaintiff's motion for protective order. Number 2, order that the deposition of plaintiff Michelle Preston proceed as scheduled or be rescheduled at the earliest possible date. Number 3, award defendants the reasonable attorney fees and the costs incurred in responding to plaintiff's motion pursuant to Florida Rule of Civil Procedure 1.38084. Number 4, impose appropriate sanctions against plaintiff for making false statements to the court. And number 5, grant such other and further relief as this court deems proper and just. Respectfully submitted, Shockett Law Group. Again, if LIEnette keeps claiming she's so innocent, she wants people to dig for the truth, why is she running from telling the truth? Why not just come forward and tell the world what Deuce has done to her? Why not just come forward and try and clear her name? Oh, because instead they're all playing a game. They're not innocent. None of them are. At all. In any way, shape, or form. And justice is coming. It may be slow, but it is coming extremely soon.